facilities that can be found behind tab 5 in the notebook. As you know, as June 15th meeting, the board approved proposed regulations by a 7-4 vote. In approving the proposed regulations, the board amended 4 sections of the draft proposed regulations that has been presented by DOE staff. One of those sections was section 370. On July 16th, the Attorney General's office notified the Commissioner that the board does not have the statutory authority to promulgate proposed regulations, citing the conflict between section 370 of the proposed regulations and section 32.1-127.001 of the Code of Virginia. The Attorney General's office stated it cannot certify the proposed regulations that were approved by the board in June. The memorandum from the Attorney General's office is behind tab 6. The Attorney General's memorandum does not cite any problem with the remainder of the proposed regulations that were approved by the board, which included a number of amendments. Therefore, I'm going to strongly encourage the board to focus on section 370. Dr. Remley and Mr. Hilbert will be presenting the proposed regulations to the board. As always, the board will be operating pursuant to Robert's Rules of Order, a summary of which can be found behind tab 15 in the notebook. Please note that prior to the final vote today on the proposed regulations, board members will be given the opportunity to comment. I'd like to now turn it over to Dr. Remley. Dr. Remley?
Present what the status report was of the licensure process under the emergency regulations, which we are currently in effect. So I will proceed to do that, and please feel free to interrupt me anytime any board member that you might have a question or more details you want to explain. To date, this slide is actually already needs to be updated. There were 20 facilities that performed 5 or more abortions in the state that were eligible to be licensed. All 20 of those abortion facilities did apply for a license. Of those, all 20 have been surveyed and have received a request for plan of correction addressing the various citations. 12 actually, I'm sorry, have submitted an acceptable plan of correction and have been licensed. So we've gone to the level of 12 in the last couple of days. 8 more have submitted plans of correction, so all 20 have submitted plans of correction. And this slide, again, the last plan of correction was just received yesterday. This is just to remind you, I know it's a busy slide, I apologize, but to kind of remind everybody where we are in the process. The form was available for facilities to be able to apply for a license starting on 12/29/11. They were due by 3/28, there's 68 under there. They've received, they were all received between 12/13 and 3/28. So those were the 20 expected applications, the 20 received. A letter of readiness for a survey, there were 20 eligible, and we received 20 letters of readiness for surveys. All surveys were conducted between May 1st and August 15th, with 20 eligible and again 20 surveyed. The plans for correction were sent between the May 23rd and 9/6, and we have now received all plans of correction. The first license was issued on 7/23, so that will have application for license renewal will be due on 3/13, and then that initial license will expire on 4/30/13. So we issued, as I said, now up to 12 licenses. I was asked to talk about what we found in deficiencies, and when we survey facilities, whether they be hospital facilities, outpatient hospital facilities, it is common to find deficiencies. We look at the areas where those are. We put these in buckets that fit to sort of the regulations that you see in front of you. Around patient care, issues with using single-dose medication vials multiple times. When we find that as a deficiency, we immediately, the surveyor who is there, immediately stops and educates the individual and the people in the institution about why this is an infection risk to immediately correct the problem. Infection prevention, inadequate safeguards to prevent contamination, functional safety and maintenance, preventive maintenance and equipment policies, procedures for how to maintain equipment, design and construction, a lot of verification of adequate airflow, and then personal, administrative, criminal background checks not conducted, and medical records being incomplete. And those are the more common deficiencies that were found. The 5 most common, because I know you all had also asked this question, building-related deficiencies were around sterile versus clean storage areas and having proper airflow, temperature, and humidity control, and the ability to separate between what's soil and not soil, having hand wash and service sinks that are appropriate, corridor and doorway width too narrow, no documentation of air filter or particle size efficiency, and the entrance not being acceptable. Again, questions have been asked by board members. Of the 12, now there will be 12 plans of correction accepted today. One had no deficiencies under the building component, which is called TAG 400. The compliance with the building design and construction requirements, which are based on the guidelines for design and construction. 7 have told us that they would renovate within 2 years to be compliant with that component of the regulations. 1 has told us that they would relocate to be compliant, and 2 are assessing whether they want to renovate or relocate and decide and complete the process within 2 years of it to be compliant. None have told us that they intend to close this time. Can I open to any questions or any additional details that you want to address? Yes.
Karen, you cited a number of specific deficiencies that were found. Regulations for licensure of washing facilities are behind tab 5 in the notebook. If there are any questions or comments as I'm going through this, please stop me and I'll do my best to respond to your question or comment. The documents behind tab 5 are a few different documents behind it that I want to point out to you so you understand what they are. The first is a cover memo that summarizes the history of this regulatory action, provides a high-level summary of its provisions, and also identifies the next steps in the regulatory process after the board approves the proposed regulations. The second document behind tab 5 is an agency background document that provides a very detailed summary of the proposed regulations, as well as a summary of all the public comment that we received earlier this year during the 30-day public comment period. The third document is the proposed regulatory text. And the fourth and final document, which is behind the yellow sheet, all the way towards the end of tab 5, behind that yellow sheet is an addendum. The purpose of the addendum, which we sent out to the board via email on September 10th, is to clearly identify the provisions of Section 370 of the proposed regulations as it was approved by the board back on June 15th, and also to specify the Virginia Department of Health's proposed amendment to Section 370, which I'm going to discuss with you in a moment. So, Mr. Chairman, Mr. Board, as you know, the proposed regulations as passed by the board on June 15th were not certified by the Office of the Attorney General because 12 VAC 5 412 370 conflicts with state law and thus exceeds the board's authority. VDH is today proposing that the board amend that section with the following language, which I'll show you in a second, which would be within the board's statutory authority in the opinion of the Office of the Attorney General. The proposed amending language from VDH that we're proposing today is on the screen, and I'll read it to you. Local and state codes and standards. Abortion facilities shall comply with state and local codes, zoning and building ordinances, and the Uniform Statewide Building Code. In addition, abortion facilities shall comply with Part 1 and Sections 3.1-1 through 3.1-8 and Section 3.7 of Part 3 of the 2010 Guidelines for Design and Construction of Healthcare Facilities of the Facility Guidelines Institute, which shall take precedence over the Uniform Statewide Building Code pursuant to Virginia Code Section 32.1-127.001. Entities operating as of the effective date of these regulations, as identified by the Department, through submission of reports of induced termination of pregnancy pursuant to 12.5-550-120 or other means, and are now subject to licensure, may be licensed in their current buildings, if such entities submit a plan with the application for licensure that will bring them into full compliance with this provision within 2 years from the date of licensure. In order to determine whether the abortion facility is in compliance with this provision, the Commissioner may obtain additional information from the facility or its architect concerning the design and construction of the facility. Paper copies of BDH's proposed amendment to this section, which is on the screen, are going to be distributed at this time by staff, so that you have them in front of you. Mr. Chairman, if there are no questions, that concludes my presentation.
Any questions for Joe? Thanks, Joe. These regulations back in June by the board were certified by the Attorney General's office. And what the BDH is suggesting is that Section 370 be worded in the way that Joe noted it, and how it is behind tab 5. Yes.
We're going to display up on the screen now. We will display the regulatory text as it was approved by the board in June. And then the amendment that the proposed amendment was distributed to you by the board.
So in a minute, I want to entertain a motion to adopt the regulations with the DEA's recommendations. It has to be duly seconded. Once that's done, it puts it on the floor for discussion and or further amendment. You can offer a primary amendment to any of the sections. It could be anything from one word to an entire paragraph. And that has to be seconded. And we have to debate the amendment. If somebody sees that maybe that needed to be tweaked, there can be a secondary amendment applied, which is an amendment to the amendment. That has to be duly seconded and discussed and voted on. If it's a word change, we find out if it's a majority, and if it is a majority, it appends to the primary amendment. We further discuss and then vote on the amendment. If the amendment is approved, it's appended to the main motion. So it becomes one motion. There cannot be an amendment to an amendment to an amendment. Roberts doesn't allow for it. It gets too confusing. So we can take these things one at a time as we have in the past. So that's how we'll proceed. I will entertain a motion to approve the regulations for licensure of abortion facilities 12 BAC-412 as presented by BDH staff.
Move to adopt the amendment language 12 BAC-5-402-370.
I second the motion.
Okay, it's moved and seconded. Does everybody understand what's on the floor? Do I need to repeat that? It's to approve regulation for the licensure of abortion facilities. 12 BAC-412.
Mr. Chairman, as I understood, Eric's motion, he was dealing specifically with Section 370 rather than the entire regulation. Did I misunderstand that?
Set forth the entire regulation. It's the entire regulation.
Right.
Does everybody understand the motion? It's the entire regulation with, as amended by the floor is open for discussion.
Chairman, I have to the department a draft of an alternate version to section 370, which is designed substantially to get us back to where we were June 15th. So my proposal is to substitute for the language just put on the floor, language that is very similar to what we passed in June. Are we going to put that up on the screen now, or? The staff earlier handed around a memorandum from me to Joe that presented the language of this amendment.
So your intent, Jim, is to strike 370 as it is in the motion and to
substitute this language. Yes, sir. That's exactly right.
As soon as Susan gets it up there, I'll give her a read. Verify, please, that this is the wording.
Building ordinances and the uniform statewide building code. In addition, all construction of new buildings for abortion facilities or additions or substantial renovations or alterations of existing abortion facilities shall substantially comply with Part 1 and Sections 3.1-1 through 3.1.8 and Sections 3.7 of Part 3 of the 2010 Guidelines for Design and Construction of Healthcare Facility Guidelines Institute, which shall take precedent over the uniform statewide building code pursuant to Virginia Code Section 32.1-127.001. To determine whether an abortion facility is in compliance with this provision, the commissioner may obtain additional information from the facility and its architect concerning the design and construction of the facility.
-1 through 3.1, you wanted that dash.
That's correct.
Can you make that correction? Jim, is that the wording that you are proposing?
Yes, sir.
Okay, there's an amendment on the floor. Is there a second?
Second.
Is an amendment on the floor to strike from the main motion 370 and to add the wording that was just read by Susan. Does everybody understand?
Is it open for
Any discussion?
Yes, I have a question. I just think that it isn't pointed out. It says pointing out the second paragraph, but I think that would be helpful to realize what the second paragraph is that's being deleted. Wasn't read, I guess, which the second, I mean, I know that you can't see all of the two things together because both of them are not on.
Right, I think, getting from the standpoint of confusion, it's probably best to strike the entire thing and substitute this, even though the same word is used. Is there anybody confused about that?
Mr. Chair, I do have legal advice on this particular amendment.
What's your mind? Allison.
Again, the first sentence of this proposal is fine. It's the rest of it that creates a problem because it does create a grandfather for existing entities that are now subject to licensure as abortion facilities. That is beyond this board's authority as we have advised in the past.
And I would like to provide my observation and objection to your observation. Of course, I respect your opinions, but I would like to go through the board member about what has been done with all regulation related to the hospital and health care facility in Virginia. VDH started regulating the life outpatient hospital in Virginia in 1977. And your document here, you can see, has a separate Virginia code deal with existing hospital and construction standard for the new hospital and existing hospital. A document highlighted here, clear. Even the first time the DDH regulated healthcare facility has distinguished between existing hospital and new construction building, fourth time in Virginia. And it has been practicing like this from the 80s, 90s, until up to 2005, when General Assembly passed regulation, which you already know, 32.1127, incorporate the guidelines. And you already read that sentence before. The Board of Health shall promulgate regulation for residential hospital and nursing home shall include a minimum standard for the design and construction of hospital and nursing home. After this, the General Assembly delegated the state authority to the board to regulate and to incorporate guidelines. And do you know what board did? This is a document I provided to you, registered in December 2005, the chapter 12, the title 12 health. The State Board of Health recognized the guidelines only intended for the new construction for the new buildings. And you see it in the regulation, what Boeing did in 2005. Before 2005, they had a separate section deal with the code, the separate Virginia code deal existed in patient hospital. And repealed because it was the General Assembly passing that bill. And then deal with that issue, they give it a call for the general building and physical plan. And I beg you to read this in all the information right here. Or that before 2005, they require center of hearing has been established under authority of Code of Virginia and constitute the minimum requirement for design. And after passing that law, they repeal, and what they say is all construction of a new building and addition, renovation, alteration, or repairs of existing buildings for occupancies as a hospital shall conform to state in the local code, zoning, building ordinance, and uniform statewide building code. And in addition, hospitals shall be designed, constructed according to section 1 through 7 of the 2001 guidelines for design and construction of hospital and healthcare facilities. So back then, the State Board of Health understood the guidelines only intended for the new construction buildings. And I read all the regulations back then. All of them exist in hospital distinguished. I can give you examples. Like upstairs, they have a distinguished hospital and the renovation construction. Review all regulations, the same thing for the healthcare for nursing home, which was registered in January 2007, went effective in March 2007. This is the Virginia Register of Regulation for a nursing home, and I think Paul Clement know about this regulation. Section BAC 5-371 and 410. All construction for new building, in addition to renovation or alteration of existing building for occupancies as a nursing facility, shall comply to the state code and zoning building and the uniform statewide building code. In addition, nursing facilities shall be designed and constructed according to the guidelines. However, care facility of the Architecture Institute of Architecture, however, the require of the uniform statewide building code and the local zone building ordinance shall take precedence. So you can understand, it has a consistent patterns of regulation in the Virginia deal with healthcare facilities, hospital, nursing home facilities, and hospices. I only give you 2 examples, but I can give you more if you like to read. So you can tell it is a pattern. And it started from 1970, 80, 90, up to date. 2005, the regulation passed, but Governor McDonough was Attorney General back then, and he agreed the guidelines is only intended for the new construction of the new buildings. And after passing the regulation, VDH worked with the State Board of Health, issued a summary to explain why they still want to keep Virginia's uniform statewide building code, and why the reason they extended over the guidelines. They understand the Virginia Uniform Statewide Code has some limitation that may be out of date. However, they didn't believe it still is mandate obligation under the section 32.117 of the Code of Virginia to ensure environment protection by the safety of the patient and employee and the public. After this,
excuse me, this is pretty much the same argument that you presented at the June meeting.
Mr. Edwards, can I just ask a question for Ms.
Sure.
Heisinger? We've heard this from you before, Anna, but what we didn't hear the last time that I'd like to hear is Ms. Heisinger to tell us why the argument that you're giving now is faulty for the bill that was passed in 2011.
which I want to cover it. All right.
And
General Assembly.
I think you made your point. Did she
Yeah.
talk to that at this point? Thank you so much.
2011 that we're dealing with today.
It's different. We were dealing back when Ann was talking about the facilities that were already licensed. We are dealing today with entities that, although they were existing and operating, they were never licensed. They're required now, when Senate Bill 924 becomes effective, to be licensed. They are all new at this point in time, based on what the General Assembly did. The General Assembly did not grandfather them from the requirements of 32.1-127.001. I think Delegate Byron made that clear today in her comments before the board. And for that reason, because the General Assembly did not create a grandfather provision for existing entities, this board has no authority to do so.
In the past,
Thank you.
there's no, in even the Senate bills, never have a language getting put in a grandfather. And I read so many bills. All right. So, but Senate Bill 924, it doesn't come in the board to impose a construction standard intended for new construction and planning, already standing. All right. Law doesn't say. It basically say it simply reclassifies the abortion clinic or type of hospital. It's not a new hospital. How do you call it abortion clinic is a
Mr.
new
Chairman.
hospital?
May I be recognized?
Yes, ma'am.
I'd like to call the pending question, please.
Okay. And I'm hanging out to stopping the debate. It can only be stopped if we have a two-thirds majority of folks here voting, present and voting. There are 15 of us here, so that number is 10 or two-thirds. So, do I have a second on the call for the question?
Second.
Okay. Any discussion? All in favor of calling for the question, please raise your hand. All opposed? Where's it go?
13I21.
Okay. We will stop debate on this and go directly to the amendment that has been placed on the floor. Does everybody understand the amendment to strike the original 370 and to substitute the wording that we have there on the screen?
We're talking about
Do you want
Jim's
to read it?
amendment, sorry, we're talking about Jim's amendment that he made.
Jim's amendment that he made. We're talking about the amendment. Does everybody understand? Catherine? Roll call vote.
An alternative amendment that basically is designed to make the language of 370 correspond to the language in the regulations governing hospitals and nursing homes now. The language is on the screen.
Susie, when you get that, I put you please read it. Jim, could you listen to my short?
All construction of new buildings for abortion facilities and additions, renovations, or alterations of existing buildings for occupancy as an abortion facility shall conform to state and local codes, zoning, and building ordinances, and be informed.
Okay, there's an amendment on the floor. Susie just read. Is there a second?
Second.
Okay, there's an amendment on the floor. It's been moved and seconded. Any discussion?
Paragraph. From a legal perspective, again, it's exempting existing facilities. If the words construction of new buildings were removed from that first paragraph, it would be fine, as is, again, grandfathered. With respect to jumping down to the second paragraph, that first sentence is subject to interpretation. So to make that first sentence comply with the law, it would have to be interpreted in a manner such that existing facilities were subject to the guidelines. And that's what, if this were to be passed, we would advise the Department of Health to apply it in that manner. And I would point out that what's missing from this is then the 2-year period to get the existing facilities to come into compliance with the guidelines. So the 2-year compliance period is gone from this. And then the last sentence of that conflicts with 32.1-127.001 by giving precedence to the uniform statewide building code. So that last sentence is beyond the board's authority. So this one is complicated from a legal perspective because I think you all might want to consider adding in to this one the 2-year grace period that you have in the current language as the Department of Health proposed.
So Allison, what you're saying is it addresses multiple issues.
It does.
Is there any further discussion?
Mr. Chairman, I have the presentations that we heard in the public comment period and all of the documents and advice that we've received in the last month or so. I think we all know what the Attorney General wants. The assertion that we lack the authority as a board to do what the previous amendment or this amendment requests us to do ignores a sort of a fundamental issue that Dr. Byron in her presentation earlier today didn't acknowledge. The Code of Virginia, 32-1.12, instills in this board a significant and very broad authority. And to my way of thinking, that is the more significant issue for us to consider at the moment. The legislature, in adopting the law that they adopted in 2011, did not tell us literally that we have to abandon 32-1.12. We have a responsibility. We are supposed to listen to medical and professional advice. We are supposed to consider the health of all Virginians. There are, unless the legislature wishes to strip from us and virtually any other board to which it assigns regulatory authority that broad power, what are we supposed to do? At the last meeting in June, when we considered this issue, this board seemed to take into account its broader responsibility. The Attorney General can advise us, cannot instruct us or direct us. In fact, this Attorney General has been wrong a time or two in the last few years. And he's wrong again this time, in my opinion, and I hope the opinion of the rest of us. And given what we did in June, we seemed to take on that. We seemed at that time to recognize that broader authority. Professor Jones from the University of Richmond Law School addressed that. We have the ability to do this correctly. Within the last year, another board in the state has taken on the Attorney General specifically with regard to this kind of action. Obviously, it wasn't the Board of Health. It was the Board of Juvenile Justice. The Attorney General said that the regulation that they adopted was beyond their authority. In that case, that board stood firm, and that regulation was adopted, despite the recommendation, the advice of the Attorney General. My colleagues, please don't be cowed by an assertion that you lack authority to do what it is our job to do. We need to find a way to avoid action that will virtually and inevitably close down a bunch of these clinics. And I'm not concerned about the loss of these clinics because abortions couldn't be performed there anymore. I'm concerned that these clinics are going to close and the gynecological services to poor women around the state won't be available. We need to keep these things open. And what we needn't be concerned. We needn't be so concerned that we fail to take action that we are empowered to take by Virginia statute. The only relevant statute is not the one that was passed in 2011. And we recognize that in June, let's recognize it again.
Thanks, Jim. Any other comment?
I have a comment. I've also served on the board.
Although we may not understand all the regulations clearly, and that's why I do all my homework. I read all the regulations while I'm asked, rather than this case. And hopefully I'll be able to make the base of decisions that recognized by the medical and healthcare professionals. One sitting here as a board shall not resign our duty to decide or even answer the AG or any other bodies.
Thanks, John.
The point I made in response to Karen's presentation a while ago is absolutely true. The tactics that these clinics have had to adopt, given that they're operating under the emergency regulations, is that they're going to attempt in good faith to comply within the 2-year time frame. We don't know how many of them are going to be able to raise the dollars necessary to fund the physical improvements that would be required. I hope some of them can. I suspect one of them apparently already is in compliance, and that one will continue. No question. I would love to be wrong about the requirement that or the ultimate impact that these clinics don't have to close completely. You'll see.
Ted, are you finished? You want to do that, Councilman?
Yes.
And therein, if a clinic is attempting to make that effort and is short some of the dollars required to make it in that 2-year time limit, but is making the effort, therein lies the opportunity for variances that has been given to the commissioner. So those kinds of opportunities to make opportunities for clinics that are undergoing hard times but still making the effort exists. It's not like it would be hard and fast if efforts are being made.
And I hope you're right.
Okay.
The guidelines. The guidelines are not designed for existing facilities. They're designed for new and substantially rehab facilities. Allison has made the distinction saying that because the abortion clinics weren't regulated before, that every building now has to be treated as new. I think Anna has explained why that's a fallacious argument. No one, especially me, is objecting to the regulation of abortion clinics. My only problem is in actions that relating to the physical plan. The other steps that we're taking in the regulations, in my opinion, totally. They involve the safety and care of the women receiving treatment at home, and that's politically fine. The issue at hand is 370 and grandfathering issue. It's not anything having to do with avoiding steps that will enhance the safety and care.
Thank you. Any other discussion? You ready to vote?
Relating to 370, I would then ask us to move to a different section, section 80, which relates to variances. And I have offered a substitute for section 80 that is designed to make the ability to grant variances more explicit. It would be a substitute to the language that now comprises section 80.
Point of clarification. Chairman?
Yes.
Practical for an abortion, or practical for an individual clinic, I would replace individual clinic with an abortion facility, because that's the term. The legal terms, I would do that. I would again consider changing waiver of enforcement and putting variance language back in it. And with respect to paragraph B, I'm not quite sure what the intent of that is, Mr. Edmondson, so I have a hard time giving legal advice on it, because I'm not, the way it reads now is that if anytime an abortion facility wanted to modify its physical plan, it would have to get written approval from the commissioner. I'm not sure if that's the intent. I'm not sure.
Again, I was looking for a way to just make it as simple and as explicit as possible. I don't mean any magic in the word enforcement, but in order to get to what you're recommending, we have to do some more surgery on the language that I had suggested here. I'm certainly willing to make the change that you're suggesting relating to the term individual clinic. We were trying simply to say that if you get a waiver of the way the building is right now, and you decide you want to do a little tinkering later, you got to get approval to do the tinkering. The idea would be in changing the first sentence of A, if if the commissioner found that failure to grant a waiver would result in something impractical relating to the clinic. I'm gonna have to do some thinking about coming up with language that would meet with Ms. Tyson's suggestion.
Jim? Yes, sir.
Need to be tweaked, maybe a lot. Would you,
Can I just say, if there is intent here that's different than what's already written, I'm certainly listening to those, and I'm not going to operate under a cloud of confusion.
As
It's very
straightforward as possible
straightforward.
that the commissioner has considerable authority to grant waivers.
She's not granting waivers, she's granting variances.
I'm sorry.
And it's
Long-
very
long-term
explicit, so
variances.
I'm trying to decide why we're going through more legal wording when it seems like what you want is there.
Mr. Chairman, may I pen the question?
I'm sorry,
Pen the question, please?
you want to go?
Yes.
Okay.